Hello, everyone. Welcome to LexTalk World Talk Show presented by Clickaway Creators. Today, we have Mr. Swarnendu Chatterjee with us. This is not the first time when we are having him for the session again. Mr. Chatterjee is the founder of Law Chambers of Swarnendu Chatterjee. He's an advocate on record with Supreme Court of India since March 2020. His specialties lie in a lot of spectrums of legal space, such as civil law, constitutional law, insolvency laws, taxation laws, labor law, criminal law, and arbitration, and so on and so forth. We have actually a lot of things to discuss about because he's been associated with legal industry since a decade and has worked with some of the top law firms across the Indian legal industry, like Luthra, so on and so forth. So without further ado, let me first of all introduce you to the man himself. Hi, Mr. Chatterjee. Welcome back. How are you doing?
I'm absolutely fine. How are you? And it's a pleasure to be back with Let's Talk World. And I have been associated with all of you since December 2020, and it was a pleasure to meet all of you in Dubai 2021. Amidst of this 3 second wave, luckily it was the 3 second wave which actually helped us in meeting you all in person in Dubai 2021 April.
Here's all us, sir, and thank you very much for joining us again. In last session, we have learned a lot about your practice and your journey in the legal industry. Today, it would be great if we can directly hop up to and understand, just dive into your practice in a sense that if you can guide our viewers or share a complex legal issue you worked upon recently, and if you can describe the complexity around it, and also if you can
Oh,
tell us how you basically approached it.
Oh, see, there are multiple complex legal issues when you practice in the apex court of the country, and you don't expect to get simple legal issues, right? In high courts and supreme courts, nowadays even in company law tribunals, you don't have simple legal issues. If the issues are simple, then why people will come to us? It's simple and as simple as that. It may seem to be a statement of pride, but it's a statement of truth that advocates on record are only 3,000 in number, maybe with the recent results is 3,253, but we do take pride in being one of the few who can act, lead, and argue before the apex court of the country being designated by them. So people come to us. It's a service to the society. People come to us with a lot of hope, right? And with complex legal issues. It may seem to us that it's very simple, but from the eyes of a layman, it is all but a complex legal issue. Because to the litigants themselves, the clients who come, their issues are the most important according to them. It may not be so important according to us lawyers. It may not reach that gravity. Like when we go to the doctors, our ailments are of the most priority, and it's the highest priority, right? So same with the lawyers. Now coming back to your question, with the complex legal issues, there are many. Couple of things which are sub judice, I cannot say, is that approvals of resolution plans and challenges to the resolution plans, which are a major challenge before national company law tribunals these days, of especially relating to the aviation industry. It's one of the most complex legal issues which I'm dealing with right now, and it's before the National Company Law Appellate Tribunal. And some of the resolution plans which I am opposing right now, approvals, are before the National Company Law Tribunal's principal bench and also the Chandigarh bench. So there are three complex resolution plan challenges which I'm dealing with, and the jurisdictions have been fastened by the judgments of the apex court, and we have to tread on a very sticky wicket. But yet, these are very complex legal issues intertwined with the social welfare reforms and the social welfare legislations which are involved in it, and the interpretations also vary from one bench to another. And another one which I can delve into is one of the most memorable moments which I had in 11 days ago. Like the case went on like this: a person's liberty was being curtailed by the Honorable High Court because of some XYZ reasons, and we came up to the Supreme Court. Now the person was almost to be taken into remand, and the Supreme Court, and on our request, I was being led by Mr. Siddharth Bhatnagar, senior advocate in that matter. So on our request, Supreme Court sat up to 4:45 p.m. in the afternoon. The hearing started at 4:10, and the hearing went up to 4:45 p.m. And the police was almost at the door of the client. And from there, we literally managed to stay on arrest order. The arrest was stayed, and it was literally one of the path breaking orders which we have, which we actually managed from the Supreme. Managed means not otherwise, but which we managed to argue well and get our client the relief he wanted. So that's one of the major complex issues which we had dealt. Although the issue might seem very simple, it's an FIR under Section 420. Even a ED and a PMLA FIR is also under Section 3, 4, 5, and 45 of PMLA, and the Enforcement Directorate comes under you, and the primary FIR is under 420, 417, and 406. The issues might seem very simple, but it's not so simple. So getting a stay on arrest order was, of course, a big challenge for me. And another three challenges which I'm facing right now, the three sub judice matters, one relating to the aviation industry and two relating to the services industry, which are intertwined with the social welfare legislations, on which more than 2,000 families cumulatively are dependent on the outcome of the case. So these are no longer simple legal issues. These are complex legal issues. And another complex legal issue which I am dealing with presently, along with those other legal issues, is a conflict of judgments between an issue which has arisen due to conflict of judgments between the NCLT and the NCLAT and that of the High Court of Madras High Court, that whether a non-member or a non-member, non-shareholder director can still approach the NCLT to challenge his removal of directorship or complain about operation and mismanagement in view of the bar under 244(1) of the Companies Act, and also the interplay of 430 where the express bar of civil courts on merit. So there are divergence of views, and the Supreme Court has interfered in the matter. So these are the few complex legal issues which I'm dealing with right
I mean, brilliant. That's when you call the spectrum is casted really wide. The net is casted really wide, and that's the perfect example of it. Uh, You're also talking about, when you're first involved with us in the middle of the pandemic, and in that pandemic, everyone saw some courts begin moving towards more remote proceedings and availability.
now. Yeah.
What do you think? Is this sustainable and a possible way to increase access to justice, in your opinion?
See, in my opinion, the hybrid system can work well. But another thing is that all courts are not so equally equipped. All courts are not so equally equipped. So, like the district courts, the major chunk of litigation arises from the district courts, right? The district courts in Delhi may be equally equipped, or in the major urban cities may be equally equipped. Not all, but some are equally equipped with the Cisco WebEx and other platforms. But at the very outset in 2020, we did face some difficulties, and we faced even in Supreme Court we faced difficulties by using different softwares. But ultimately, we found our way, and this has been, and but the pandemic has brought access to justice delivery system at our doorstep. Like even a person sitting in Delhi, like uh, Delhi can appear in Mumbai before a Mumbai court, and person sitting in Mumbai can appear before a Delhi court, or a person sitting in Calcutta can appear elsewhere, or a person sitting abroad can appear in India before courts in India. So all these are there. But given the fact, now in India, I still believe access to justice delivery system, although can be done by the hybrid mode, but not all the lawyers, according to me, not all the lawyers are well equipped or well funded to have these basic systems in place. All the lawyers are not so blessed to be well off, and all the places are not so well off to have access to internet system, and the judges and the honorable judges of the courts are also facing issues, some issues like online projection of orders or online projection of some documents. These are not so prevalent. These were not so prevalent pre-COVID. All the judges who have come up to this stage have all dealt with hard copies. We are coming to terms. It is a learning process for us. Yes, it's a very advantageous position for all. Like me sitting here today can appear before a court in Chandigarh or in Mumbai or elsewhere or some other part of southern states in India. But again, given the given everything, like everything remaining constant, but nothing is equal to a physical appearance before a court, where of course you can read the mind of the judges, you can see what the judges are thinking and what the other side is trying to say. So it's an effort in which we have been trained, but nonetheless we should accept the technological advances, and also it's a boon, not a bane. And also the fact that the huge number of disposal of cases have resulted well in this pandemic times on the on WebEx platform. But one thing which has to be ensured now is to recording of evidences for online platform. People need not go to the court to depose. This is happening in Delhi. This is happening in some parts of Bombay as well, as per my information, but not in all places. So the district courts must be equipped in all places for an online recording of evidences in trials, in all kind of trials, criminal, civil, matrimonial, everything, every aspect of every aspect. Because access to justice delivery does not only mean higher courts, it means lower court also.
Mhm. That's very right. So what you're saying is it's an issue with infrastructure, along with the adaptability of the system, of the new
Yes,
system.
absolutely. Infrastructure, government is taking steps. They're taking positive steps. We are seeing the Chief Justice of India and the Law Minister updating us with the steps which have been taken at the Delhi High Court and the other high courts calling for reports. But the judges have to be trained and well equipped. They are currently, some of the judges are brilliant, well, have dealt with it brilliantly on the e-court system on or on the online platforms. But some district level judges, the district level judges, they have, with the voluminous records in place, digitization of trial court records is very important. In high court, you have to do e-filing. In company courts, you have to do e-filing. But in trial courts, you have to have the system of digitized records. Otherwise, another pandemic can ruin can actually derail the entire system. If the district court system, if the district level system is not having a strong foundation, then everything can get derailed.
Oh, that's very right. Uh, I have also asked, and you of course answered that, what's the possible way to, increase access to justice? If not the hybrid platform, if there are, these issues that is happening, and of course it will take its own time. How would you rate the current legal system's drive towards encouraging access to justice? And is there a tangible movement in closing the justice gap?
Yes, like we are in a developing state. We are not in a developed state. You see, so in trial courts, you can see in trial courts and in some courts, you can see the litigation is pending for years and years and years together. You see for example, let's say ordinary civil suits, which can be decided in say very less time. We lawyers are responsible. Sometimes we lawyers are also responsible. We take adjournments after adjournments after adjournments. Like it's like Sunny Deol's movie, like Tariq pe Tariq pe Tariq. Like the judges should come. We lawyers should also develop things as to ways and paths to aim at quick disposal. And also the concept of pre-litigation mediation in commercial courts act has been a path-breaking one. And this pre-litigation mediation can be done in other suits also, like say the matrimonial suits, like where the divorce petitions are contested. So that's a concept which the government may aim at, the legislature may aim at, having a pre-litigation mediation, because number of contested matters can get solved there. So you don't have to go to the courts, like a pre-packaged insolvency, where you don't involve the delivery, the judicial system not so much. You have a pre-packaged system or a pre-litigation system where you do not get embroiled in an actual litigation before the honorable court. Now, another thing is that some matters do take some time because of the complexities of the issues and the numerous amount of pleadings and the parties involved. Now, we cannot have such a system, or we should have such a system like we are driving. Some judges do try to limit the number of hours or the time to be taken by counsel for arguing a matter, for placing the matter before the honorable court. One counsel cannot take n number of days or n number of hours. It has to be done away with. It has to be supplemented with written submissions. So, of course, access to justice delivery system and the mode of disposal are connected, right? Of course, the judicial vacancies are of a concern, but the government is taking positive steps to reduce it, and the Supreme Court Collegium is also taking positive steps to ensure filling of judicial vacancies, and they are sometimes ensuring that the tribunals under various central enactments and state enactments do not go vacant. They are trying, like the FEMA Appellate Tribunal, the DRT, the DRAT. The government is trying, the NCLT or the NCLAT. They're trying to ensure they're trying to ensure vacancies. So filling up of vacancies. So that is one part of the access to justice. Another part is like only a fraction of our humongous population are aware of the legal position. So the legal aid system is not working properly in the country. Access to legal aid. Whenever two people are embroiled in litigation, people think that, oh, we are embroiled in litigation now. It will be I cannot spend that much of money. So let us move away from it. It's not that. You should fight for your rights. One should fight for their rights and access to legal aid. So lawyers who are doing good, like our seniors, we ourselves who have made a mark supposedly in this field, should always help the legal aid system and should be doing pro bono matters for helping the poor and aiding justice delivery system. This is a very important part. Like Justice Ramanna, our Honorable Chief Justice of India, had made a statement that every person should be made aware of our fundamental rights of enshrined under Part 3 of the Constitution. So every people should be made aware, and justice delivery system should be at the doorsteps of every person of our nation, be it be from the far northeast like Nagaland or the Arunachal, the farthest of the farthest areas. No person should suffer the ills of injustice. Like they say, like it is popularly said of the quote of I would like to quote Martin Luther King Jr. that injustice is access to injustice is of course leading to injustice all over the world. So this is something which has to be prevented.
That these are some of the powerful words that can summarize this answer. Really appreciate that, Mr. Chatterjee. Now, to also understand, a lawyer like you who have been busy in doing a lot of things around himself. Time is money, in any profession, and in legal, it's most of all. How do you ensure to make the best of your time as a lawyer specifically?
See, first of all, I would like to quote late senior, late senior. I would like to quote my late senior, late Shri P.P. into it for the same. Like he used to say a very important word and a very important phrase rather. The non-paying client is your bhagya vidata and the paying client is your anya data. So both are important. Your bhagya vidata is also important. Your anya data is also important. You can charge as much as you can from your paying clients, but the non-pay you should not ignore your non-paying clients. They are also just like I said, you should help people to get justice. So this is a social this is not a so of course people will say this is not a social welfare. What we are doing is to run our house. We lawyers also have to run our show. So basically, like doctors do, like chartered accountants, this is also a profession. We are professionals. The thing which we have to ensure is that we do not treat clients as banks or money making institutions. It is a justice delivery system. We are trying to help people to get justice, but of course justice comes with we also need money. We are also in this profession as lawyers. We also want to earn. Everybody wants to earn money. There is nothing wrong with earning money, but also to ensure that each person gets justice. It is not only about the money. Money will come, but ensuring proper justice or ensuring the effort to have proper justice for every client, irrespective of his paying capacity, is the need of the hour. There are many lawyers who do pro bono, many senior lawyers who do pro bono. This is one of the conditions today for getting designated as a senior advocate under the conditions enumerated in the Indira Jaising judgment of the Supreme, delivered by the Honorable Supreme Court. So it is, time is money. My like, people who can afford to pay my charge, there will be 10%, there will be 50% of the clients who will be able to pay my charges. There will be another 25% who will be able to pay some, a fraction of my charges, and there will be another 25% who won't be able to afford. That doesn't mean I'm inaccessible to the rest 25, the balance 25. I'm accessible to the balance 25% as well. But I would rather utilize that effort equally, and I will balance that effort equally, to, for which I'm giving the 75% as well as to the 25%. So it has to be equal. So Anyadata and Bhagyavidata goes hand in hand, not separately.
Brilliant. Again, few more powerful words by Mr. Chatterjee. And Bhagyavedata is someone who writes your destiny. I mean, for our international viewers. And Annadata is someone from where you earn your bread. So these are two references that he's using here. Okay. Now we missed actually one point. I believe we have discussed a lot here, and we have learned a lot about some new things coming out of you. Your journey has been changed, since we last talked and now. So I want to talk about that as well a bit.
Yeah.
How do you see, and till date, you have been associated with Luthra and Suffer and Partners, and some of the top names in the Indian legal industry. From there to going independent, how does it feel?
Oh, for every advocate on record, it has to be an independent. If you have to be an arguing counsel, the sine qua non is you have to go independent, because maybe in firms, some firms will allow you to argue, but not always. And see, both are different kinds of practice. There are some advocates on record who are a part of top law firms. I was a part of two top tier firms of the country, Luther L&L Partners, currently known as Luthra and Luthra, and Saraf and Partners, both top tier firms of the country. And I cannot deny the fact that I have learned a lot from these two firms. But but my goal and aim was something different. My goal and aim was to be an arguing counsel, and is to be an arguing counsel myself. So, and I'm an designated advocate on record of designated by the Honorable Supreme Court. So, to enumerate such practice, to develop such practice, you have to, and to be an arguing counsel, you have to start arguing every case which your client entrusts. Like 80% of the cases you need to argue. Then 20% you can engage senior counsels on the instructions of the client. But you should be ready with every file so that you are ready to argue the matter yourself. So, do of course, like, money is on one part, firms pay you well, and so you are well off. It is difficult to let go of such money and start your independent practice. But as you say, it takes time to flourish. But once you have that confidence within you, that okay, you can, and you have clients coming in, and you have the ability to argue and generate clients, then I think, if one has the patience, you are bound to succeed, because it takes time. Of course, there will be months where you will earn something less than your existing salary, but there will be months when you will be earning 5 times your existing salary. So your balance is out, right? And then you will be your own paymaster. Like, when people ask me, what do you like, how much do you earn, I say, I help people earn. So this is one. So you are an employment generator also. You generate employment because people work with you. You pay them. You help budding lawyers to develop with whatever knowledge you have gained so far. So you have to be confident, and it should come from within, that okay, I'm ready to serve, and I'm ready to be independent. Of course, it does take a monetary backing if there is a monetary issue involved, but monetary issue is secondary, and primary issue is your confidence. If you have the confidence and the guts to strive forward, then you should. There is nothing called a perfect time. Today is the perfect time. Go forward. And whatever clients come, you see in law firms, you have a practical difficulty of getting of venturing to clients from every strata. They have a CSR practice, no doubt about it. There are clients who are, of course, on pro bono basis, but you get certain mandates you have to do. But here on your own, you can serve as per your own wish, right? You don't have to depend on something. You don't have to be on something. So firm practice is, of course, on one side where you, of course, in a firm practice, where I was as a principal associate, you learn how to deal with different client of high profile clients. So when high profile clients comes to you with some complex matters, you know exactly how to execute it. In a law firm, in a level of a principal associate or being a partner, learns you how to learns teach you learn how to execute. It teaches you execution and teaches you responsibility, how to get the work done. It's not just getting work done through people is an art. It again requires some amount of knowledge. Then how to speak to clients from different strata. Like you won't speak to some, of course you will speak in the same manner with that of a person from the lower strata, and that with of the highest strata of a, like somebody like a businessman, top ranked businessman, and somewhat both of them have equal access, equal in the eyes of law, but the requirements may be different. The way of speaking, the gate, the exposure may be different. You have to speak in a different manner. They are of course coming with a lot. All of them come with a lot of expectations, but you have to see the person in front, who is there, how you want to cater yourself, your get up, everything matters. So law firm teaches you that kind of aspect, and independent practice teaches you the sense of responsibility as well, because you are on your own, nobody else will be responsible, so you are responsible for your own acts, right? So that has been my journey. Like it was quite difficult for me to take that situation, to leave a very handsome package and the prospect of being elevated in the coming years, and so on and so forth. But I had to take that steps. I had to take that step because I wanted to be an arguing counsel. I wanted to venture on my own. And now with the COVID being on the decreasing slope, I told myself, now this is the right time. I'm venturing into the 10-year bracket. So this is the time when I can venture out and I can practice. I can start practice on my own. And anytime I can go back to any firm. I have been with two top tier firms of the country. So I have spent 2.5 years. So anytime if I wish, of course, now I don't wish, after 5 months of independent practice, I don't wish to go back. That's a statement on air in front of everybody, in front of the media. I don't wish to go back because of the independence. Because let's just say a tiger looks nice when it roams in the jungle and feeds on its hunt, and feeds on the food which it hunts. So, and when you taste blood, you continue to taste blood. You don't go back. You don't go back to your den and sleep and sleep like and sleep in slumber, right? So I don't. So that has been my journey. Basically, I've seen two worlds, and I've chosen this world to be my future.
Yeah, really, once a hunter, always a hunter. And they also say what comes easy goes easy. So if it's taking time, it will last long. So with that, Mr. Chatterjee, it was a really powerful discussion today. It was a really brilliant discussion. I learned a lot, and especially seeing because we know you've been associated with a law firm and now being an individual practice, and your profile for our viewers as well. For Mr. Chatterjee's profile is more towards value creation. They say it's a business of law, but it's also about value creation. So that is the tangent that he always focuses upon. And kudos to you, Mr. Chatterjee, for that. So thank you very much for sharing such great insights with us again. And we look forward to having such great chat with you in the future on some other trending topics in the international legal industry. Thank you very much.
Thank you.
This is all ours. And for our viewers, if you like this chat with Mr. Swarnendu Chatterjee, please make sure that you like this video, you share this video, and you also click on that red button and subscribe to Click of a Creators YouTube channel to appreciate what we do. And you have more coming in from investigators. This was Sagar for Let's Talk World signing off.